sentencing people is it's not easy sometimes because, especially, I'm going to say for me, because I like to look at the person and I like to know about the person. So I have a good idea of who I am sentencing instead of just seeing the black and white. On black and white, if I were to just look at the facts of the case as alleged in a criminal complaint and those things, on black and white, it's serious. It's an OWI 5 or 6, and somebody could have been killed, somebody could have been injured, that could have been you, it could have been someone else. And if judges sentence on the black and white, you could go to prison for up to 10 years. All right, how are you doing today? I'm good. I'm sure you're feeling a little anxious.
Yeah,
a lot
a
of feelings.
little anxiety there, but
You got a cool shirt.
what?
You got a cool shirt.
Thank you.
Miss Hanu, timing wise, we're all good for today to proceed as it is.
Yes, Your Honor.
Excuse me a minute, I put my hearing aid in.
Okay, you do that. And if you need me to speak up, let me know. If you need me to turn up the system, let me know.
It's just my hairs.
So who's here with you?
That's my mother and my aunt.
Very good to have their support.
Here we go.
Anybody was curious, records prior to 1999 are stored in the basement of the Hennepin County Courthouse.
What?
I went to Hennepin County to dig through records.
Did you find anything?
No.
Nothing? But you tried hard. That's good. That's the problem with having things old, but now with everything in technology, we'll have records forever. Unless they let us purge them and delete them from a system.
Well, Washburn County's been down for about a week.
They're still down.
Yeah, they're going to be down for at least another week.
Everything?
So the DA's office runs off the state system. So they're all running off hotspots right now. So there's no phones, there's no Wi-Fi.
Wowza. All right, we will go on the record in the matter 25 CF 159, 25 TR 956 and 957, State of Wisconsin versus Eric Gustafson. The state appears through District Attorney Kevin Schmidt in person. Mr. Gustafson appears in person with his counsel, Emma Hanu. We're set today in this matter for a plea and sentencing. The parties have reached an agreement. Ms. Hanu, can you please recite the agreement for the record?
Yes, Your Honor, the agreement would be for Mr. Gustafson to plead to count 1, operating while intoxicated, a 5th or 6th offense. The remaining counts would be dismissed and read in. There are additionally 2 traffic matters that would also be dismissed and read in. That would be 25 TR 956 and 957.
All right. And Mr. Gustafson, that is the agreement that you've reached with the state?
Yes, Your Honor.
You understand that pleading guilty to an OWI 5 or 6 means that it's an immediate report to jail and that it's a mandatory minimum prison sentence. And that would be, as of me taking your plea, you're going to go and be incarcerated.
I understand.
Okay. All right. So I do have in front of me the plea questionnaire waiver of rights form. Do you recognize the document?
Yes, Your Honor.
Is this the document your attorney went over with you?
Yes,
Did she go over it thoroughly with you? That is essentially word for word?
yes,
And do you understand everything completely?
yes.
If you did not understand something, did you ask her to explain it to you?
I understood everything.
All right. And so you signed the second page.
Yes, Your Honor.
You're pleading guilty to 1 count of operating while intoxicated, 5th or 6th offense. You are 70 years old. You have 12 plus years of schooling. You can read, write, you understand the English language. You are receiving treatment for a mental illness or disorder, which would be ADD or ADHD,
Correct.
and you are taking medications for that. Is that correct?
Up until my last appointment, because they won't allow it in prison, so I told them not to make it, because it has to be monthly, I have to go in.
Okay. Now today, since you have not been taking it as you have been regularly prescribed the medication, are you in a place today where you can say that you are able to comprehend and understand everything that's going on?
Yes, Your Honor, it only affects my ability to concentrate.
All right. Now, are you in a place here today where you can concentrate
Yes,
fully?
Your Honor.
Okay. Other than that, no medications, no drugs?
I have my
Or
own
alcohol?
medications, but those are just blood pressure, cholesterol.
All the normal health
Yeah.
stuff? Okay. Now, because you're charged, well, first off, did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt as to this OWI 5 or 6?
Yeah,
And did she go over with you the mandatory minimums as well as the possible maximum penalties you face upon conviction?
the minimum, yeah, I don't even know what the maximum is.
Well,
10 years.
Oh, 10 years, okay.
all right, so your attorney just informed you the maximum possible penalty. So you understand the mandatory minimum as well as a maximum penalty.
Yes,
Okay. Now, because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed right there in that first page. Your attorney is showing you your constitutional rights right now. Did your attorney thoroughly go over those rights with you?
yes,
And do you understand them completely?
yes.
Do you need me to go over those rights with you in any more detail?
No, I'm fine, Your Honor.
Okay, so you understand your rights completely. And do you understand that by pleading guilty, you are waiving and giving up those rights?
Yes,
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
yes,
Do you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
that's why I don't own any.
Excuse me?
I don't own any, so that's
Oh,
why.
that's good. And you will no longer be able to vote in any election until your civil rights are restored.
With this political climate, why bother?
Well, that's good too. Okay, but every vote does count. Okay, so you understand your rights and you understand what you're giving up here today and that it's a felony. You
Yes,
understand that with regards to this charge, the operating a motor vehicle while under the influence, 5th or 6th offense, the state would have to prove on or around November 15th, 2025, in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant. Do you understand what the state would have to prove?
yes,
Do you understand that upon conviction of this Class G felony, you may be fined not more than $25,000 or imprisoned not more than 10 years or both? That's the maximum possible penalty. Do you understand that?
yes, Your Honor.
Do you also understand that upon conviction due to this felony and the seriousness of this OWI, that the court shall impose what's called a bifurcated sentence, meaning some time that you would sit in prison and time that you would sit outside of prison on extended supervision, that the court shall impose a confinement portion of that sentence to be not less than 1.5 years of initial confinement in prison. Do you understand that?
Yes,
And do you understand that in certain circumstances, it's not very common, but in certain circumstances, the court could find that a lesser sentence would be reasonable if the court finds the best interest of the community would be served and the public would not be harmed for a lesser sentence than that mandatory minimum. Do you understand that?
yes, Your Honor.
But you understand that's not an everyday thing that occurs. You understand that?
Yep.
Okay. So you understand the minimums, you understand the maximums, and you understand what the state would have to prove your guilt beyond a reasonable doubt. Now, do you understand that there is an agreement here reached between the parties where the parties would recommend to the court just to sentence the mandatory minimum in this case? Do you understand that?
Yes,
Do you understand that I'm not bound to follow that? which means I could look at this case, I could hear the arguments, and I could sentence you beyond that minimum sentence, and I could go all the way to the maximum penalty if I thought it was warranted. Do you understand that?
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Now, did you go over that criminal complaint with your attorney? That's the initial charging document that says basically what happened that day and why you were charged with the crimes.
Yes, Your Honor.
And you're looking at that right now with your attorney, correct?
Yes, Your Honor.
Now, for the most part, are those facts accurate?
They are.
So you were pleading guilty to an OWI 5 or 6 because are you guilty?
Yes, I am, Your Honor.
And so you're admitting to operating while under the influence on November 15, 2025?
Yes.
Ms. Hanu, may the court use the probable cause section of the criminal complaint to find a factual basis?
So stipulated, Your Honor.
Has anyone made any threats or any promises to you, Mr. Gustafson, for you to plead guilty today?
No, Your Honor.
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing.
Yes.
Are you doing so voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has she answered all of your questions?
Yes.
Has she looked at this matter thoroughly?
Yes.
Has she looked at the discovery, which is the evidence here in this case?
Yes.
And has she discussed it with you?
Yes.
Has she looked whether or not you have any legal defenses in the case or a lack of defenses? Did she say, you know what, looking at this case, it looks like we can argue to the jury and or the court that you have this defense and we can probably argue that and maybe find you not guilty? Mr. Gustafson, you can have a few minutes to talk to your attorney.
Oh, okay, yeah. Yes, we talked about it.
Okay, and as she stated previously, I don't believe it was on the record, but prior to the record, that she went to Hennepin County. She went to go look at other OWIs that you've been convicted of to see if they had records of this, to see if you could possibly have what's called a collateral attack, which could be something that assists you in this case. Did you talk to her about that as well?
Yes, Your Honor.
Okay, so are you satisfied with her services?
Yes.
Do you have any questions for the court or for your attorney before I proceed?
No.
Okay, Ms. Hanu, did you go over the facts that are alleged in the criminal complaint with Mr. Gustafson?
Yes, Your Honor.
And did you go over what the state would have to prove his guilt beyond a reasonable doubt?
I did, Your Honor.
And the mandatory minimums and the maximums?
Thoroughly, Your Honor.
And you discussed whether or not you could see any defenses or a lack of defenses in this case?
Yes, Your Honor.
Do you believe he is competent to enter his plea here today?
I am.
Any reason the court should not proceed and ask for his plea?
No, Your Honor.
All right. Mr. Gustafson, as to count 1, OWI 5 or 6, a G felony, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be dismissed and read in. Count 3 will be dismissed and merged into count 1. The ticket matters will also be dismissed and read in. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Thank you. I think that the statutory minimum here is appropriate in this case. The defendant's got 5 prior OWIs, meaning this is a 6. The significant things that counsel for that are 1, the defendant's old age, which is 70. 2, he's been accepting responsibility quickly, not just with the court, not dragging things out, but also when he was in contact with the police out at the scene, he didn't really deny or anything like that. 3, he has a significant additional penalty in this case, and that even though this is a 6, it's his first felony conviction ever. The way Minnesota counts convictions is much more lenient than Wisconsin, which is how he's dodged that. His convictions are spaced out such that he never had 3 within a 10-year period, so he never had a felony OWI in Minnesota. So he's going from his last OWI in Minnesota, where the penalty was just, 90 days jail, probation with 275 days stayed and imposed, to accepting prison today, which is a big jump. And I think that that alone is sufficient and there's no need to ratchet higher than that. Thank you.
Thank you. Ms. Hanu.
Your Honor, the factors you must consider here, the gravity of the offense, is the statute as well as common culture creates the gravity is high here. I'm sorry. Operating while intoxicated is a issue here in Wisconsin. But the other factors that the court must consider is Mr. Gustafson's character and his rehabilitative needs and the protection of the public. Mr. Gustafson, as the court saw when we came here for a bond modification, was adamant that he wanted to go to treatment. He wanted to go get help prior to what he knew at the time would be an immediate report to prison. Mr. Gustafson was released from the Burnett County Jail on January 22nd of 2026. I have in my hand here a letter from the Veteran Affairs Association that by February 1st of 2026, Mr. Gustafson took the time to go to St. Cloud, Minnesota and enter into the mental health residential rehabilitation treatment program with the Veterans Affairs Health Center in St. Cloud. He completed that program on March 19th of 2026. Mr. Gustafson is committed to his sobriety. He served this country. As I think we all know, veterans often will struggle with sobriety, addiction issues following their service. As Mr. Gustafson has related to me, this came from a downward slope where he knew we needed help and he didn't get it in time, and now we are here. Mr. Gustafson is taking responsibility, and he is here today for the court to impose a sentence. I think the mandatory minimum is more than appropriate and adequately protects the public, because even after a term of confinement where Mr. Gustafson could get out, do his extended supervision and be done, he intends to re-enter into the Veterans Affairs treatment programming to ensure long-term sobriety.
All right, thank you. Mr. Gustafson, is there anything you want to add or you want to let me know?
No, like I said, I knew I was going, I just procrastinated. That's my biggest crime. Just trying to find my paperwork from previous groups I was in.
All right. Mr. Gustafson, sentencing people is not easy sometimes, because especially, I'm going to say for me, because I like to look at the person and I like to know about the person. So I have a good idea of who I am sentencing instead of just seeing the black and white. On black and white, if I were to just look at the facts of the case as alleged in the criminal complaint and those things, on black and white, it's serious. It's an OWI 5 or 6, and somebody could have been killed, somebody could have been injured, that could have been you, it could have been someone else. And if judges sentence on the black and white, you could go to prison for up to 10 years. I like to know the person who I am sentencing, to know the history, to try and craft a sentence around that person and that person's needs, as well as then looking at the punishment factor and what I am directed to do by the legislature and by my higher courts. From the very beginning, you have wanted to be responsible and be accountable, and you understood that, and you knew that you could just stay in custody and wait until the matter worked itself out, such as now, and plead guilty and go to prison. You could pay the bail and get released and then live your life until it reached resolution, such as today. But you decided to pay the bail, get out of custody, go to the veterans facility, and get the help that you need, mentally, physically, all around. even still knowing that there is a mandatory minimum prison sentence in this type of case, you still went ahead and got the help that you need as a person. That's commendable. OWIs are very serious. Not only the legislature tells us that they're serious with continued increase, significant fines and fees, and significant penalties for OWIs. But you and everyone else in this courtroom, and including myself, know how serious they are because we either know somebody, had somebody in our family or a friendship or an acquaintance, or read in a paper or watched on the news somebody who was either killed or severely injured in an accident caused by intoxication or people being under the influence. So we all know that it's serious. You do have a criminal history, and it's obvious with the OWIs. This would be your first felony OWI, and in Wisconsin, it's mandatory prison. The community, I have to look at the community and protecting the community, and here, the community is going to be protected, one, because you went and got the treatment and the help that you need. And second, because this is a mandatory prison sentence and you're going to be incarcerated and you're going to get that punishment end of this crime. And so the community is going to be protected that way. Hopefully, when you are incarcerated, you will avail yourself of all of the programs and all of the activities and all of the things that you can to continue to improve yourself and to be able to have more self-reflection as to why this happened, what led this to be the result, and how you can catch things sooner or seek help faster instead of getting into another position like this. You're a 70-year-old man who appears to be kind and sweet, and you have support of your family, which is great to see too. So sentencing you today is not an easy thing, knowing that I must, I have to sentence you to prison. I don't think there's anything here, though, that would state that I need to or should look beyond the mandatory minimum prison sentence, because your criminal OWIs they're sparse in time, and you're doing all that you need to do, which is, again, commendable. So the court is going to sentence you to 1.5 years of initial confinement with 3 years of extended supervision. You will not be entitled to do any early release programming for that initial 1.5 years of incarceration, because that is a mandatory minimum sentence. However, once you're placed on extended supervision, if you are revoked off of that, at that time, you would be able to engage in some types of early release programming, substance abuse programming for early release, if you are revoked off of extended supervision. I am going to order $4,962 in fines and fees, plus a $10 blood draw fee. With each and every OWI, the fines and fees get higher and higher and higher. And I'm trying to give you as much of a break as I can, knowing that you're taking the responsibilities, because this could be up in the $6,000 range. I understand you're a veteran. I understand you're on limited resources. We do have $2,000 bail that has been posted. That'll go towards your fines and fees. When you're released from custody, you can petition the court to look at the fines and fees and see if there's anything that you can give back to the community, working with the veterans and doing those kinds of things. where I could perhaps knock some of the fines and fees off for community service.
Well, I've already made the decision to help out at the VA and local animal shelters.
And I'm glad to hear that. And you're telling me you're doing that without even having an incentive, without even having a benefit from doing that. So that makes me even happier. So when you are released, and if you are looking, or you would like some money knocked off to the extent that I'm able to, I am very happy to take your service with those organizations and help deduct some of the remaining cash that need, fines and fees. I can't waive any surcharges, but I can look at other fines and fees to try and whittle it down.
No, I don't,
We're out of custody. You will be making payments in the amount of $150 a month. If you're unable to afford that, again, you can petition the court. We can go over your finances and we can see if that needs to be looked at. Sometimes the court looks at your financial situation and looks at everything and actually increases the monthly amount. So just be sure that you don't think that that is a possibility. That would be, well, when he's on extended supervision, yeah, that would be to the Department of, correct, no, it won't. Let's have him pay us when he's released, because the Department of Corrections, he's gonna probably be watched in Minnesota, supervised in Minnesota, because you live in Minnesota, correct?
yes, but when I get out, my family there lives up in Viking Village. At first I'll be going there
Okay,
because they need some help
all right.
mentally.
I do have to state that the Department of Corrections, in their discretion, could take a percentage for these kinds of fines and fees, and I'll leave it to them, but I'm comfortable with my comfort is you don't need to start making payments until after you're released, but the Department of Corrections gets to do what the Department of Corrections wants to do. And so if they have the authority to do that and to collect, and if they are looking at collecting, then that's something that you unfortunately have to take up with the Department of Corrections when you are in custody. On extended supervision, absolute sobriety, no alcohol, no bars, taverns, liquor stores, or any establishments that have the primary purpose for the sale or the service of alcohol. You will have alcohol testing. How many days of jail credit?
69, Your Honor.
69 days of jail credit will be applied to your sentence. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. If you fail to pay your fines and fees, not only will the court enter a civil judgment against you, because you're always going to owe it, but the court will issue a warrant. You could sit up to 6 months in jail. This is a felony, no use or possession of a firearm for life, no voting in any election until your civil rights are restored. You're going to need to contact Burnett County Probation when you're in custody, or they will contact you, because when you are released, you're going to want to do that interstate compact, and you're going to want to transfer supervision to whatever jurisdiction you're residing in after release. I believe that covers everything. I need to order your DNA. The jail will make sure that they take that. In a case like this, I do not believe you can request it be expunged from the system, but you can try. It's a written letter to the Department of Justice. Ms. Hanu can help you if you wish to look into that.
At my age, I'm not too concerned about that.
Well, I'm glad to hear that. No, we don't have to worry about any past crimes where DNA will solve the mystery. So that's good. Thomas Avenue, is that your home?
That is my nieces. I've been there, but like I say, I'll be going there. I've been here for the last month helping them, and then I'll be going there when I first get out, and I don't know where I'm going, because I think she's gonna be moving to Florida while I'm incarcerated.
Okay.
I'm
just
hoping
make-
to go back to the neighborhood I used to live for 18 years till I had to move. That's why I went overboard there.
oh, just make sure that you have the Department of Corrections and the court updated with any change in address where you want mail to be sent, but they'll update us with where you are incarcerated.
I do have a change of address into my niece over in Hastings, Minnesota, that my mail will be going to.
You have an address you want to give us right now?
Yes. Let me pull it up. I'm trying to be proactive. Nineteen 88 Nininger, and that's spelled Nininger Road, Hastings, Minnesota, 55033.
Okay, thank you. All right, Mr. Schmidt, what am I missing?
Nothing from me.
This is an immediate report, so once you're done here today, in court, you have to go to the jail, turn yourself in, and get booked in, and, good luck to you, Mr. Gustafson.
So I brought these.
Good luck. Anything you think I'm missing or need to state on the record?
No, Your Honor.
Okay, thank you.
I just go down to the sheriff's office.
Yes, Ms. Hanu, do you have another case? Can you just show them how to?
I have,
Thank you.
I've been there before.
Okay.
Have a good day here.
Um. We will go on the record in the matter 26 CT 27, State of Wisconsin versus Russell Lindbaum. The state appears through District Attorney Kevin Schmidt in person. Mr. Lindbaum appears in person without counsel. We're set here today in this matter for an initial appearance. Mr. Lindbaum, you look nice today. Thank you for dressing appropriately.
Thank you, Your Honor.
I can't recall. I know one of your last convictions was an OWI, was it correct?
Yes,
And do you recall what it was? 4, 5, 3?
it's been about 6 years.
Okay, but it's been 6 years. 6 years. Are you able to get your driver's license?
Actually, it's been 7.
Oh, that's good.
7.
Time flies.
Yes.
And you're doing good. I haven't seen you in here
Yes.
for things, so you're doing great.
Unfortunately, I was getting prepared to get my license back, and tomorrow I get it back. I'm eligible to get it back tomorrow,
Excellent.
and I just got to go through the hoops to get it Minnesota satisfied with the Intoxilock. It's got to be installed through them.
Okay.
And then it's all good over there.
Okay, and do you owe them any fines and fees or anything?
Not that they told me. I called them, and I'm pretty sure I took care of that when I got my settlement.
Okay, well, good. Excellent. So you just have to get the Intoxilock on, and then do you need any SR22 insurance or anything?
Yes, I'm pretty sure I'm gonna probably need that. I've asked for a bunch of, well, I've asked for insurance quote, and I got millions of them now, so I'll get that too. I got the money for it, so.
So how long do you think it's gonna take you to be able to get all of this stuff in place?
Oh, give me a month at least.
Give you a little more than a month, and then we'll come back and we'll see where you are. Because Mr. Schmidt, what would the offer be if he is able to get his license?
We dismissed the case.
That's awesome.
Be dismissed.
Cool.
So I'm gonna give you some time to be able to get all of those things taken care of. And then let's say that you get your license before this next court date I give you. You will not have to come back. Just make sure you bring your license, a valid license or copy of it to Mr. Schmidt's office, the district attorney's office. And then it can be dismissed with paper, okay?
Cool.
But you do understand that charge and those maximum penalties if you are convicted on that criminal complaint. You understand those?
Yes.
Do you need me to read anything to you?
No.
Okay, so as of right now, I'm just gonna say a not guilty plea, and then again, do what you need to do, get your license, and it'll be dismissed.
All
Are you
right.
still on North Point Lake Road?
Yes,
Telephone ends in 8395.
yes.
Excellent. Now let me get a date. I'm gonna give you plenty of time to hopefully get all of that taken care of.
Great. Thank you.
No problem. I am so glad to see you like this, Mr. Lindbaum. You look great.
All right, thank you.
October 22nd at 11 o'clock, okay?
Okay.
October 22nd at 11. Hopefully that's enough
Well,
time.
Hopefully
Get it
that
done.
doesn't take me that long.
It shouldn't. I just want to
Okay.
make sure you have enough time to do it.
All right.
Okay? You
All
can
right.
come up and get your notice and your.
Thank you very much.
Keep up whatever you're doing, Mr. Limbaum. Good. I don't, Ms. Bearhart, what is it? How many days have you, or how long have you been sober?
5 years.
Oh my God, I am so proud of you, Mr. Lindbaum. So proud of you. Keep it up. Ms. Bearhart, have you applied for a public defender?
Yes, I did, and I did not qualify.
I did not think you did. Have you had Mr. Chapman in the past?
Yes, I have.
That's, I believe you have. Okay. Good with him?
Yeah.
Okay. I am going to need to have you have to fill out that application again, that you did in the past.
Okay.
And can you do that before you leave today?
Yes.
And I can reappoint Mr. Chapman. I will need $500 down, I think, let me look at your old one, because I can't remember how much I required down before.
I do recall it was 300.
That's right.
Are you able to go any lower, as I got school shopping for my kids and then 2 of their birthdays this month, and just trying to play catch up with everything.
I'll do what I did before 300. I'll just do that 300 instead of the 500. So $300 down, and then it'll be $100 a month.
Okay.
Okay, thereafter. Let me take a look. And I can give you a little bit of time to get that $300 to be able to pay it and to put it down. But you're going to have to do that before Mr. Chapman is going to be officially appointed.
Okay.
But I'm going to schedule your next an adjourned initial appearance date for September 24th at 9:15.
Okay.
Okay, you'll get a notice, September 24th, 9:15. And let's have the $300 paid by September 4th. Okay, that gives you 3 weeks.
Okay.
That work?
Yeah.
Okay, so pay it by September 4th, $300 and $100 a month. And then the $100 a month would start then in October, since you're going to pay the 300 in September. Okay. And then once I get that $300, Mr. Chapman will be appointed. You can talk to him about this case and we'll get the matter moving. Okay.
Okay.
All right.
Thank you.
So you can come get your notice. Again, fill out that application before you leave.
Do I get it from up front?
From up front.
Oh,
Yes.
it's right on the wall. So I can't remember what number it is, but it says court appointed attorney.
Okay. Okay. Douglas Murphy. Do you have Douglas Murphy? Matthew Whiteside. We will go on the record in the matter 26 CT32, State of Wisconsin versus Matthew Whiteside. The state appears through District Attorney Kevin Schmidt in person. Mr. Whiteside appears in person with counsel Joel Feliski making a special appearance on his behalf here today. Mr. Feliski, does he qualify for a public defender?
Thank you, Your Honor. I completed an application with Mr. Whiteside, and at this time, due to his income, he does not currently qualify. He has not received a copy of the complaint in this case. He did advise that his address had changed, I believe, somewhat recently. So at this time, I provided him with a court-appointed attorney application. He's going to fill that out and have that turned in expediently.
Here is the criminal complaint served by the district attorney. He has a copy of that. Would you like to review that and come back and have your first hearing, and then we can push this off a few months for a status and get an attorney appointed?
Yes.
Okay, so Mr. Felicity, can you just go review the criminal complaint with
Certainly.
him, and then we'll recall your case, okay?
Of course. Okay.
And make sure you get it, you have the application, fill that out, and then bring it to me.
Okay.
Okay? Who's waiting for me? But Douglas Murphy Jr.? Okay, so who's here for court? Who are you?
Austin Bruss.
That's what I'm thinking. You might be with Amy, our clerk right now. Mr. Bruss. Maybe not, you're Austin Bruss?
Oh, he has the diversion program, I think.
Okay.
You
All
want to
right,
stop by the DA's office and check in with Laura down there about the diversion program?
all right, so Mr. Bruss, go-
Sign.
okay, so you're not on the calendar today. I don't even see, oh, just a diversion program letter. Okay, you're good to go with me, so you're not gonna be missing court or anything. Just go take care of what you need to at the DA's office. Who are you, sir?
Larry Colby,
Colby.
Kolb,
Can you spell it again?
Kolb as in Victor.
Larry Colby. Mr. Colby, you are out with Amy, so go to the clerk's office and ask for Amy,
Okay,
and then she'll handle your matter, okay?
okay, thank you.
No problem. You're here for court too?
Yeah.
Who are you?
Jaden Peterson.
Peterson? You're with Amy too. So just go out there. Are you okay? What happened?
A crash.
Oh,
I ended
no.
up breaking my back and
How awful. How long do you have to wear that?
oh, and a couple more weeks, huh?
Well,
Go back for x-rays on the first.
well, good luck. How are you doing?
Pretty good.
Doing good? That's, seems like it's bad. All right, go talk to Amy and she'll be able to handle you and help you with that.
Thank you.
You're not on my calendar either.
It's for child support.
Oh, okay. Well, that's why your name's not popping up, but child support, that's 10:30, so. All right, it looks like we need to call Douglas Murphy. Oh, but something about Douglas tracking with this.
Dr. Jody.
The who?
Jody at child support.
Okay. Oh, good. Hmm. 6 CF 62. All right, Mr. Schmidt, with regards to Mr. Murphy, Douglas Murphy, I don't know why he's not here, but they're drug paraphernalia, but he does have a felony case that he's coming back on September 10th. Should I just move those to that, or do you have a different way that you want to handle the other thing?
I take no position as this is a former client of mine.
Excellent. Okay, so let's just move Mr. Murphy's cases to September 10th at 9:45.
Oh, yeah, I put that note in.
You did.
I'm so sorry, just kind of.
That's okay. It's a day. Yeah, so move the 26-113 and then these cases on for today onto his felony date and time. I'll get a break. Previously noted, State of Wisconsin versus Matthew Whiteside. Mr. Felisky, you were able to go over the criminal complaint with Mr. Whiteside.
That is correct, Your Honor. I believe he does understand the charges here and the maximum penalties. To all three counts, we will enter in pleas of not guilty, waive formal reading, and would request a status conference.
Now, guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Mr. Felisky, can you go grab a nice little pamphlet from Mr. Schmidt, please, and give that to Mr. Whiteside? Mr. Whiteside, this is the Intoxicated Driver Intervention Program. If you complete this program, there's a lot of benefits that you get. A, you'll get your license faster if there is a conviction. B, if you do have to, if there is a conviction and you have to sit jail time, you would be eligible to get the mandatory minimum with an OWI2. It's 5 days of incarceration. C, you would get the ability to serve that time on an electronic monitor at your cost, but you could serve it on house arrest and go to work and go to church and any AA meetings or anything like that that you wish to do. So there's lots of benefits to doing that program. So please look into that. And then if you are interested, I would say call Miss Anderson or Mr. Hatch right away and let them know so you can get enrolled, because it takes about 4 months to complete that program. Okay. And you wish to have an attorney appointed to you. Did you fill out that application?
Not yet, Your Honor. I
Okay.
will rate. when I
Please
leave.
fill it out before you leave and turn it in. What I believe, I think I'm going to appoint an attorney, Christopher Gramstrup. He's a very good attorney. He's from Superior up north. And so I'm going to need to have you put a deposit down. Can you let me know, where do you work?
Concrete, Curtis Concrete.
And you work full-time,
Seasonal work, but full-time and seasonal.
seasonal? So right now you're working until the
Winter,
weather
yep.
changes. And how much do you make an hour?
25.
25, that's good wage. So what the court is going to require would be $500 down. And so the faster you pay that $500 to the clerk with that application, so fill that out. If you can't pay the $500 now, that's not a big deal. I can give you a deadline to do that. But the faster you pay that $500 deposit, the faster I can get Mr. Gramstrup on this case. And then we can go from there, okay?
Okay.
All right, so it would be $500 down and $100 a month, what you would pay towards your attorney, okay?
Okay.
Let me get your next date scheduled. And Mr. Schmidt, I do realize that this is on your week, but I will switch it to Mr. Vila's week after the next hearing, September 10th at 9:45. September 10th at 9:45. Mr. Whiteside, I'm going to guess you typically would be at work right now.
Yes, Your Honor.
So I am comfortable if you wish to appear by video conference like Zoom or by telephone, calling the court at that date and time.
Okay.
Okay, then you don't have to miss too much work. You can just take a little 15-minute break. We can have your hearing. And essentially, it's just that hearing is going to be for me to find out, are you doing this program? Do you wish to do this program, etc.
Okay.
All right. Yes. was
Yes,
gonna
I
give you
can,
1 second. First, I want to make sure that you have the deadline. Can you pay the $500 by the 21st of August?
Yes, Your
We're
Honor.
doing it as quickly as you can, but please, again, make sure that application is filled out before you leave. Updated address?
Yes, Your Honor, I have 6098 Bass Lake Road in Danbury, Wisconsin.
And telephone, does it end in 1471?
No,
Can I get an updated, please?
715-791-4263.
All right, maybe send you text message notifications?
yes, Your Honor.
All right, thank you. You have your next date. You can come up here and get a notice. The clerk will print out a notice for you and it will have the calling instructions on it, okay?
Thank you.
Thank you. We are adjourned. Mr. Felicity, can I ask, are you gonna see Miss Hanu sometime?
There you go.
Can you might need to write this down if you can. She has a client by the name of Devin Coatsy for felony fail to pay child support. And he is supposed to be on my child support sanction today, but he is asked to have it moved. And because he was going to call Miss Hanu or something of that nature. So if you can just give her an update.
Oh, of course.
Did Mary ask you if September date works?
She did, and I'm available anytime with her. I'm not super sympathetic to his claims, but
No, and it's fine. I just have, just to make sure that that works and we can hear everything at the same time, because chances are great he's gonna have Miss Hanu. So,
In contact.
okay, thank you. So Devin Coatsy is off for today, but let's do we're done, right, Mr. Schmidt?
And I shall leave.
Child support. Okay, how about Mr. Trutzman?
You can do it. You got it.
Down and slide back. We will go on the record in the matter 23 FA 63 in re the support or maintenance of CJT. Appearances are we do have Shannon Tretzman appearing in person without counsel. We have Corporation Counsel Stephanie Thomas Schmidt. We're set here today in this matter for a sanctions hearing. Mr. Tretzman was found in contempt for failing to pay child support. He was set on a purge order with purge conditions. There's claims asserted by child support agency that Mr. Tretzman has not met his purge conditions. Mr. Tretzman, do you understand you have the right to have an attorney?
Okay,
Yes, you would have a right to have an attorney. And so you can retain your own attorney, private attorney for this matter if you wish. If you do not, if you qualify for a public defender, you may be able to get one appointed to you. So for today's purposes, you are not with an attorney, so you're representing yourself?
okay,
Okay, is that a yes, you are?
yes.
Okay. So Ms. Thomas Schmidt, can you please update the court and let me know what it is you are seeking?
Yes, Your Honor. By way of background information, Mr. Tretzman is on, frankly, a pretty high order. And since this purge began, he's made some payment almost every month. There's the month of June that we didn't receive a payment, various amounts. He's approximately $2,200 short on what his total purge would be, which is why we're bringing this action. It looks like there was an involuntary intercept at one point, which helped catch some of that up from taxes, if I'm reading this correctly. But Mr. Tretzvin has made, I'd say, a decent amount of effort. He's not all the way across the finish line yet, but I think we're on the right track. And so my request is to continue the purge for another year. And this has been discussed with Mr. Tretzvin before, but the Child Support Agency and myself, and I would hope the court strongly urge Mr. Tretzvin to fill out the paperwork and file for a modification to review what the order should be set at, given his actual earning circumstances, as opposed to information that we had when it was set some time ago that ended up not panning out the way it was conveyed that it was going to.
This is a weird case all around. I knew I recognized Tretzvin without, and I knew you were here for the child court sanctions and those types of things. But then I'm like, Tretzvin, this is that weird motion to void marriage issue and how that came in front of the court. And so quite honestly, I don't recall where the custody, the placement, the matter is. Do you currently have placement of the child?
I was granted shared physical placement. Lately, it's been extremely difficult to see her. She's in therapy.
How old is the child? I can't
She's
recall.
9.
9. I
She's
knew
9.
She was younger. Okay, so with that, do you understand what Ms. Thomas Schmidt is
Yes.
asking or saying?
Yes, I understand. Jody and I had a conversation. She explained it further.
I mean,
Now
I can explain
understand.
it to you. I can tell you, I can't give you legal advice. It's on your
Yes.
shoulders to file, to not file, to
Yeah.
research, to not research, to do those things. But it sounds like child support and Ms. Thomas Schmidt, like Jody and Ms. Thomas Schmidt understand the situation and where it was originally ordered and where things may go, or it may go a different route, but nothing can happen until you actually do something.
Right, file for modification.
That, and that's on your shoulders.
Okay.
So right now, what Ms. Thomas Schmidt is asking is, we have to continue as what the order was initially ordered.
Mhm.
And you have to meet those requirements. If you don't, you could go to jail.
Mhm.
So she's asking to extend the purge for another year, to continue the way it is, for you to purge yourself from that contempt and any of the sanctions. But in the meantime, you figure out, I mean, you can continue with this order if that's what you wish, or you can have the court review it and review all of your information to determine whether or not there has been that substantial change in circumstances and go from there. So.
Could I ask a question,
You may.
please? I didn't understand that last part. It sounded like there are two options.
Well, you can either continue exactly how it is right now and pay the child support what it is, meet the purge conditions, or you can have the court review it and review a modification request.
That's the modification process.
Correct.
Okay.
But I can't do anything unless you
I
ask
do-
the court to do something.
Okay.
So that's where that is. So do you agree right now to extend the purge, to continue with that purge for an additional year, if or until the court determines something else?
Yes.
Okay. So, Ms. Thomas Schmidt, the court will grant your request as stated on the record. And I guess we'll just wait and go from there.
Okay. And Your Honor, I'll ask that continue through July 31st of 2027. And for Mr. Tretzvin's knowledge and for the court's knowledge and approval, the language of the current purge specifically says the dollar amount. I would be changing that to pay your support as currently ordered, such that if it goes down at a review, the purge amount would go down as well.
All right, how much is in arrears right now?
$5,863.12.
And so you know, Mr. Tretzvin, that can't be reduced or wiped out or anything. The only way it can be is if Ms. Fountain agrees to do that, because the longer you continue to get behind, the longer or the more that this is going to build, and you will owe it forever until it's paid off. So you live in Danbury?
St. Croix Falls.
Okay, and what is it that you do for a living?
I'm picking up carpentry work now.
Oh, excellent. Okay, and so you do that all by, do it all by yourself? You do it as a sole proprietor?
Yes.
Okay, all right. So you don't have a set dollar amount an hour, or it's just per project?
Correct.
Okay. All right, so you're gonna have to figure out, and that makes it a little bit more difficult when filing for a modification request, because you're gonna have to produce financial documents, financial records for not only for my review, but child support, all of those things, such as tax returns and those kinds of things, okay? I don't think we have to set another date or do anything like that.
No, I'm not requesting that.
Okay. All right, then we're good to go. Thank you. How do you get so tan? We're adjourned. How do you get so tan while building carpentry?
I
doing
had
carpentry?
to give up on excavating. I can't take heat anymore. I've been sick,
This is
so
a hot
I've been
summer.
sick so many times this summer. I missed work on Monday. Sick. Yeah,
That's not good.
not making excuses. I just.
Nope, I understand. It's been a good summer if people are
Oh,
on the water all the time.
If you're on the water, in the water. Yeah.
Yep, exactly. Okay.
You're good to go. Stay in touch with Jody if you have any questions,
This
okay?
is the paperwork that I need.
Yes,
Jody?
yep.
Thank you very much.
You're welcome.
You're on.
Ms. Pulaski. We will go on the record in the matter 24 FA 49 in re the sport or maintenance of SDP. Appearances are, we have Ms. Pulaski, Regina Pulaski appearing in person without counsel. We have Stephanie Thomas Schmidt appearing for Corporation Counsel. We're set today for a motion hearing for sanctions, a request for sanctions. Ms. Pulaski was found in contempt and placed on a purge order. There's allegations and claims that she has failed to meet that purge. Ms. Pulaski, do you understand you have the right to an attorney?
Yes,
And you're going to be representing yourself here today?
yes,
And do you understand why we're here?
yes.
Ms. Thomas Schmidt, please update the court and let me know what you are requesting.
Yes, Your Honor. Ms. Pulaski's been on a purge. Her order accrues at $803.29 per month. Her purge is established at $500 per month, taking into account the amount of her accrual versus what she reasonably would be able to pay. Ms. Pulaski has been making payments, not necessarily full payments, but she's been making payments at least since she was given an imposed and state sanction in April. She did bring in a payment today that brought her purge current through the end of July. So I give her a lot of credit for that. Our request is to continue the purge, and that Ms. Pulaski strongly consider the same review papers that we spoke about with the previous gentleman, for the same reasons. And that Ms. Pulaski either file her taxes or provide verification that her taxes were filed. If we could verify a mailing address, My understanding is Ms. Pulaski is working at 10th Hole Bar. I don't know if it's mostly for tips or if it's something slightly more under the table or what the situation is, but 10th Hole Bar is not honoring a withholding. So if Ms. Pulaski would continue to self-pay and just provide verification that she's remaining working, since they're not doing that. And the standard contact provisions, notify of any changes in address, employment, et cetera.
All right, Ms. Pulaski, do you understand what Ms. Thomas Schmidt is asking?
Yes.
And she would like to extend the purge for an additional year. Are you okay with that?
Yes.
And are you still at 10th hole?
Yeah.
And I know that you're trying to find other work or do other things, but it's been a little bit difficult.
Yes. I do have check stubs somewhere, I think maybe, that I could bring in. And I thought I did turn the paperwork in, but I might not have.
Nope.
I don't have any paperwork
Okay.
filed.
So the paperwork I'm talking about, Your Honor, is the request for the child support to review it and then bring the motion saying this is what we think the order should be amended to.
All right, sounds good. She's within the time frame where she can ask for a child support review?
Yes.
Okay, and I know, I'm gonna tell you, I have seen you at your ups, I've seen you at your downs. But to me, right now, you're doing good.
Right.
You're working hard. She not only here, as she now brought her purge current, which I'm so proud of you, you are working hard. She's done the same thing in other matters where she's needed to pay money, and she's there and she's putting in the effort and she's doing what she needs to do. And
It's hard.
it is hard. And you're doing it all by yourself, Ms. Pulaski, which makes it even harder. You have to keep it up because you're doing great and you're doing it for your kids. And I know that this isn't the case to talk about it, and you don't have to say anything if you don't want to, but to me, you look good. You look so.
Thank you.
So are you doing good?
I've been doing very good.
How long have you been sober?
I think like 6 months now.
Because you look good. You may feel a little down because it's hard and you're struggling, but you're putting in that effort. Yet you cleared the purge, you cured it through July. You did what you needed to do. You were behind a little bit.
I think that was when I went to jail and I had to bail myself out. That's why that $500. I was behind, I believe. That's why I missed that month's payment.
Let's not go to jail anymore.
I know.
All right, but you're doing good and you're working hard, and I can see it. Ms. Thomas Schmidt can see it, so can Jody. You're doing what you need to do. Okay, keep it up.
Thank you.
If you're feeling the stress and you're feeling the pressure, reach out to somebody. Don't go down that other way. Okay. All right, so I'll extend the purge and
And I'm living with my uncle again at 4727 Gasoline.
4727 Gaslin.
Do you know what that is?
Okay.
Webster.
Yes.
Okay, well, good. That'll help give you a little bit more stability too.
Right.
Anything else, Ms. Thomas Schmidt?
Just extending through July 31st of 2027.
Yes, that works. The court approves. Keep it up, Ms. Black.
I guess if I'm trying to think how to phrase in the order such that if Ms. Pulaski does submit the review paperwork and her order is lowered below that $500, that her purge would be whatever that lower amount is.
That won't pay off my arrears, will it?
No, but we're gonna focus on getting you current and doing what you need to do now so that it doesn't grow, and then we'll start looking at adding arrears payments.
Okay.
And I think you said it pretty well, and how you need to say it in order, just,
Right.
touch it up a bit.
Mhm,
But I understand exactly what you're saying, and I think Ms. Pulaski does too.
mhm.
So,
Yep. So if your order goes down to 400, your purge would then be 400.
Right.
I mean, you can keep
You
paying
can-
more.
Yep,
Right.
absolutely, and start
Already
chipping away
paid.
at the arrears, but I don't want you to be put in an less than fair position.
Right.
This courtroom hearing took an unexpectedly positive turn when the judge came face to face with a defendant who was finally getting his life back on track. At the beginning of the hearing, Russell Lindbaum appeared without an attorney for an initial appearance. The judge immediately noticed a major change, telling him that he looked good and thanking him for dressing appropriately. The conversation quickly turned to his past OWI conviction and his suspended driver's license. But then came the good news. Russell explained that he was eligible to get his driver's license back the very next day. He only needed to complete the required Intoxilock installation and handle his insurance requirements. The judge gave him more than a month to get everything in order. Even better, the prosecutor offered a clear path forward. If Russell successfully got his license back, the case could be dismissed. The judge didn't just focus on the case. She recognized the progress Russell had made. Later, she learned that he had been sober for 5 years, and her reaction was genuine. She told him how proud she was and encouraged him to keep going. But the hearing wasn't all second chances. Another defendant, Matthew Whiteside, appeared on 3 criminal counts and entered not guilty pleas. The judge encouraged him to participate in an intoxicated driver intervention program, explaining that completing it could provide significant benefits if there were eventually a conviction. Then the courtroom shifted to a serious child support sanctions matter. Shannon Tretzman had previously been found in contempt for failing to meet child support purge conditions. He was approximately $2,200 short on his purge amount, although the court acknowledged that he had been making payments and was moving in the right direction. The judge explained the stakes clearly. He needed to continue following